Somewhere right now, in a van, on a rooftop, or clipped to a lamppost near you, there may be a device pretending to be a mobile phone mast. Your phone doesn't know the difference. It connects automatically, the way it connects to any tower with a strong enough signal. And in that moment, without a single message sent, without you doing anything at all, your phone has just told a government agency exactly where you are. This isn't a conspiracy theory. It isn't something from a film. In the last few months, fresh reporting has confirmed that UK agencies have been quietly expanding exactly this kind of phone tracking technology. And for years, the police response to basic questions about it has been the same 3 words: neither confirm nor deny. In this video, I'm breaking down exactly how this technology works, what the actual law says about when it can be used, the genuine safeguards that exist, and the ones that quietly don't, and what your rights are if you ever want to challenge it. I'm Oliver Bennett, criminal defence solicitor here in England and Wales, and this is one of those topics where I think every single person in this country deserves to understand what's actually going on, whether you've ever been near a police investigation or not. Let's get into it. For years, most people assumed police tracking of your phone meant one thing. They ring up your network provider with a warrant, and the provider hands over records. That still happens, and we'll come back to it. But what's made headlines recently is something different. The quiet, sustained expansion of a piece of technology called an IMSI catcher. IMSI stands for International Mobile Subscriber Identity, a unique number tied to your SIM card. An IMSI catcher works by pretending to be the strongest, most attractive mobile phone mast in the area. Your phone, doing exactly what it's designed to do, automatically connects to whatever mast offers the best signal. And if that mast is actually a box in the back of an unmarked van, your phone has just handed over its unique identifying numbers without you ever knowing it happened. Some versions of this technology can go further, intercepting calls and text messages, or blocking a phone from connecting at all. For years, investigations by journalists and privacy groups established that at least 9 police forces in the UK had purchased this kind of equipment, often disguising the spending under a deliberately bland acronym CCDC, standing for Covert Communications Data Capture, rather than the far more recognisable term IMSI catcher. And more recently, reporting has revealed that even HM Revenue and Customs, the UK's tax authority, has been quietly building up similar surveillance capabilities of its own, well beyond what most people would expect a tax office to be doing. So this isn't new technology appearing out of nowhere. It's an old capability that keeps expanding, largely out of public view, and that's exactly why it keeps resurfacing in the news. The official line: what law actually governs this? Here's where I want to be precise, because this is genuinely complicated, and getting the framework right matters. The main piece of legislation governing this entire area is the Investigatory Powers Act 2016, often nicknamed the Snoopers Charter by its critics. It replaced most of the old Regulation of Investigatory Powers Act 2000, RIPA, and it sets out, in quite granular detail, the different categories of surveillance power available to police and other public authorities, along with the safeguards that are supposed to apply to each one. When it comes to something like an IMSI catcher, the position, according to the UK's own oversight body, the Investigatory Powers Commissioner's Office, IPCO, is that police would need what's called a Targeted Equipment Interference Warrant, authorised under Part 5 of the Investigatory Powers Act. Equipment interference is the modern legal term for interacting with a device to obtain data from it, which is exactly what an IMSI catcher does. In principle, this kind of warrant requires senior authorisation and independent oversight before it can be used against a specific target. That's the official position. Notice, though, what I said a moment ago. Police forces have consistently refused to confirm or deny whether they use this technology at all, even when asked directly through Freedom of Information requests. This is known as a neither confirm nor deny policy, or NCND. A tribunal ruling in England and Wales has actually upheld the right of police forces to maintain this position. So while we know the legal framework that's supposed to apply, We don't get clear case-by-case confirmation of when, where, or how often it's actually being used. IMSI catches get the headlines because they sound dramatic. But honestly, the far more common way police track phones day to day is much less exotic. It's called communications data. This doesn't mean the actual content of your calls or messages. It means the metadata: who you called, when, for how long, and crucially, which mobile phone mast your device connected to at the time. Because phones are constantly talking to nearby masts, and because those masts are in fixed locations, this data can be used to build what's called cell site analysis, effectively plotting your rough movements over time, mast by mast. Under Part 3 of the Investigatory Powers Act 2016, police and a wide range of other public authorities can request this kind of data from telecommunications operators, your phone company, essentially. Here's the important safeguard that's genuinely worth knowing. Since reforms introduced a few years ago, most of these requests can no longer simply be signed off internally, officer to officer. They generally have to go through an independent body called the Office for Communications Data Authorizations, OCDA, which sits under the Investigatory Powers Commissioner. OCDA's job is to independently check that each request is genuinely necessary and proportionate before it's approved, rejecting or sending back applications that don't meet the bar. This matters because it's a real structural check that didn't always exist in this form. Before these reforms, a lot of these decisions were effectively made in-house, by the same organizations requesting the data. Now, in the great majority of cases, an outside body has to independently sign off on it first, except in genuine emergencies or specific national security situations, where a more urgent internal process can apply. While we're on the subject of new ways police can track people, it's worth briefly mentioning two other technologies that often get lumped in with phone tracking, even though they work differently. Automatic number plate recognition, ANPR, tracks vehicles, not phones directly. Cameras read number plates and log where and when a car passed a particular point, building a movement history for the vehicle rather than the device in your pocket. Live facial recognition is a camera-based system that scans faces in a crowd and checks them against a watch list in real time. It doesn't touch your phone at all, but it raises very similar questions about location tracking and consent, and it's been the subject of real legal challenges in the UK courts over how it's deployed and safeguarded. I mention both because if you're thinking about how you might be tracked day to day, your phone is genuinely only one part of a much wider picture. But for today's video, let's stay focused on the phone itself, since that's what most people are actually worried about. I don't want this video to just be doom and gloom, because there are real safeguards built into this system, even if they're imperfect. Let's go through them properly. The double lock mechanism. For the most intrusive powers, like intercepting the actual content of your communications, the law requires what's called a double lock. Sign-off from a senior official within government, and approval from an independent judicial commissioner, a serving or former senior judge. Both have to agree before that kind of warrant can be used. Independent authorization for communications data. As we covered, most requests for your call records or location-based mass data now have to go through OCDA, an independent authorizing body, rather than being approved internally by the same force requesting the information. The Investigatory Powers Commissioner's Office, IPCO, conducts ongoing, independent inspection of how these powers are actually used across more than 600 public authorities, including police forces, councils, and government departments, checking for errors, overreach, and non-compliance, and publishing annual reports on what it finds. The necessity and proportionality test. Underlying almost all of this is a legal requirement that any request must be genuinely necessary for a specific, legitimate purpose, and proportionate to the intrusion it causes. A request that sweeps up far more information than is actually needed for the investigation at hand can, in principle, be challenged and refused on exactly this basis. These are real, meaningful checks. But, and this is the honest part, they exist mostly behind closed doors. You, as the individual potentially affected, are almost never told in the moment that any of this is happening to you. Which brings us to the part most people actually want to know. Here's the honest, slightly frustrating truth. In most cases, no, not directly, and not at the time. Covert surveillance is, by definition, covert. You won't get a text message telling you your movements were logged via cell site data, or that an IMSI catcher may have swept up your phone's identifiers along with everyone else's in the area during an operation, targeting someone else entirely. This lack of individual notification is one of the most consistent criticisms leveled at this entire system by privacy organizations, and it's a genuinely fair point. The safeguards are largely institutional, not personal. That said, you're not completely without options. If you're charged with an offense and communications data or intercepted material is used as evidence against you, your solicitor is entitled to examine how that evidence was obtained and can challenge its admissibility if the process wasn't properly followed. This is a genuine, practical safeguard that operates through the criminal justice process itself. You can make a complaint to the Investigatory Powers Tribunal, IPT. This is a specialist tribunal that exists specifically to hear complaints about the use of covert investigatory powers by public authorities, including the police and intelligence agencies. Even without proof that you were personally targeted, if you have genuine grounds to suspect unlawful surveillance, for example, in the context of certain protest or campaigning activity, the IPT can investigate and has, in a number of past cases, ruled that specific surveillance conducted by UK authorities was unlawful. You can submit freedom of information or subject access requests, though be aware that, as we've discussed, many requests specifically about surveillance technology, like IMSI catchers, will simply be met with the NCND response. Let's bring this down to earth. This isn't a video designed to make you feel paranoid. It's designed to make you informed. So here's the practical version. Understand that basic phone hygiene has limits, but it's not worthless. Turning off a phone limits real-time location tracking to its last known connection point, but it doesn't erase historical data already generated. A new SIM in an old phone, or vice versa, doesn't create a clean break either. Device identifiers and account connections can still link the two. Know the difference between content and communications data. Encrypted messaging apps can make it much harder for anyone to read the actual content of your messages, but they generally don't hide the fact that a connection or call was made, when or for how long. That metadata picture can often still be built through communications data requests, regardless of which app you're using. If you're ever actually arrested and your phone is seized, remember what we've covered in other videos on this channel. The police seizing your phone and actually extracting the data on it are two separate legal steps, and you are not automatically required to hand over your passcode simply because you're asked. That requires a formal, specific legal notice. If you're involved in campaigning, protest organizing, or journalism, and you have genuine reason to believe you may be a target of surveillance, rather than simply incidentally caught up in a wider operation, organizations like Privacy International and Liberty actively support and sometimes bring cases to the Investigatory Powers Tribunal on exactly these issues, and are worth researching if that applies to your situation. And generally, stay informed rather than alarmed. The honest reality is that the overwhelming majority of people in the UK will never be individually targeted by an IMSI catcher or a targeted equipment interference warrant. Those tools are, at least officially, reserved for serious criminal investigations. What's changed recently isn't that ordinary people are suddenly being tracked one by one. It's that the scale and secrecy of the underlying capability has become clearer, and that's worth understanding regardless of whether it ever directly touches your own life. Let's pull this together. The headline story is the quiet expansion of IMSI catcher technology. Devices that trick your phone into connecting to them instead of a real mobile mast, potentially revealing your location and, in some cases, more. In principle, this requires a targeted equipment interference warrant under Part 5 of the Investigatory Powers Act 2016. But police maintain a strict, neither confirm nor deny position on their actual use. The far more common, everyday method is communications data, call records and mast connection data, obtained under Part 3 of the same Act, and since recent reforms, generally requiring independent sign-off from the Office for Communications Data Authorizations, rather than internal approval alone. Real safeguards exist: the double lock mechanism, independent authorization, ongoing inspection by IPCO, but almost all of them operate behind the scenes, without individual notification. If you want to challenge something, your main routes are through a criminal case if evidence is used against you, or a complaint to the Investigatory Powers Tribunal. Here's the principle I want you to leave with. None of this technology is inherently sinister on its own. Surveillance powers, properly used, genuinely do help solve serious crimes, and the safeguards we've discussed are real, not decorative. But a democracy runs on the public actually understanding what powers exist and how they're supposed to be checked. The less transparent that picture is, the harder it becomes for any of us, including the courts, to hold it properly to account. Knowing how this system works doesn't make you paranoid. It makes you one of the relatively small number of people in this country who actually understands what neither confirm nor deny is quietly sitting behind. I'm Oliver Bennett. Know your rights, because the people who understand the system are always in a stronger position than the people who don't. I'll see you in the next one. This video is for general information only and does not constitute legal advice. Laws and technology in this area change quickly. If you have a specific concern, speak to a qualified solicitor or an organization such as Privacy International or Liberty.